Thank you, everybody, for joining the webinar today. I'm really thrilled that I'm able to host this session. Got some great panelists, going to go talk about a lot of things having to do with the intake process. But before I get started, I'm going to do some introductions. So I'll go first. I'm John Blake. I'm the Director of Sales here at Gemini Legal. We're striving to be the best resource for workers' comp firms across the state of California, which is one of the reasons why we do these webinars. If you'd like to see any of our past webinars, you can go onto our YouTube channel at Gemini Legal, and you'll be able to find them there. Also, if you have questions, you can put them down either in the chat or the Q&A. We'll be going to those questions from time to time during the webinar. And if we're not able to answer them during the webinar, we'll strive to answer them afterwards, okay? With that, I'm gonna turn it over to Taylor to let him introduce himself.
Hey, everybody. Thanks for coming to the webinar today. I'm a trial lawyer, third-party civil litigation specialist. I really focus on brain injuries. And one of the things that I want to demonstrate, and John, if you could pin me, or if I share screen, can we pin that? That'd be great. One of the things I want to share is what I've gone through over the last couple of years. A little bit about me, just not to kind of toot my own horn, but I've gotten some Trial Lawyer of the Year awards. I found out I got one of the largest verdicts in California and one of the top 100 in the United States. So there's just to say that I try cases, I like trying cases, but what I'm really talking about today is in terms of brain injury cases and third-party cases, I missed a lot of cases, and that's kind of what I want to demonstrate is
Well, before we get there.
Yeah, do you want to go on through everything?
Let's let everybody introduce themselves, and then we'll
Sure.
hop right in.
Absolutely.
All right. So next is Erica Wise.
Hey guys, my name is Erica Wise, and I am a hearing representative for the law offices of Goodchild and Duffy. I've been in the industry, working in the industry for about 17 years or so. And have worked at several firms known in the industry. So, and yeah.
Good deal. Well, thanks for joining us. And last but definitely not least, Eric, go ahead.
Good afternoon, John, and everybody attending. Thank you for being here. I'm a workers' comp lifer. I've been doing workers' comp for 33 years, the last 22 as a applicant's attorney, and the last several years focusing on subsequent injuries fund claims, which is the subject of my talk today. So thank you, John, for inviting me. Appreciate the opportunity.
Wonderful. Thanks to have you. I'm sure that everybody's going to have quite a bit to bring to this session on intake. So let's go ahead, and the reason why I wanted to do this webinar is I've been out visiting firms and hear from my reps quite a bit that a lot of firms struggle with the intake process, quite frankly. They're having problems either spotting a big case or having a detailed enough intake process or knowing what to look for SIBTF in the intake process, which is why I got these specific 3 panelists. And I think they have just a great amount of information to share that will help all of the law firms that are participating, that are attending here today. So with that, I'm going to go ahead and start with Tyler. And I know you have a screen to share, and I'll see if I can get you pinned so we can get this done correctly here.
Sure. And in the interest of time, I'm going to move pretty quickly. We have an enormous amount of great resources between Erica and Eric that are going to be sharing. And so if I move past something quickly and you want to ask questions, my contact information is going to be at the end. And the reason it's so nice that John was inviting me to do this today is I used to take every single intake call that our firm did. I am not just saying, hey, this is what it was. I went through the pain of trying to figure out what case is big, what case is not big, how it works. And I would work the case up from the time we took the phone call through trial. And some of the ones I'm going to be showing you today were specifically that. So I was on the front lines of how to spot the big case. What I want to really show is This is the intro for our firm. We're known as the Ernst Law Group. It was my father before me. We have 6 lawyers. We don't do any pre-lit. If we take a case, we're filing a lawsuit. We think it's significant. So really what we're focusing on is big cases. But this is what I want to tell everybody is you miss good cases. And I say that because I've missed good cases. I don't say that to say, hey, you know, we always worry about it, but this was one of the first big cases I worked on. This slide is actually the reject letter we wrote to the client saying, you don't have a case, we're not going to be able to help you. The client followed up 6 months later and called us back. This was pictures of the injury. He was hurt on the work site. He was operating the machine that the beam, basically a big piece of heavy metal came down and crushed him, that he was operating. He's the one operating the beam that crushed him. And we thought, well, you know, I'm not sure, it's all work comp, there's exclusivity there. And I was like, I'm going to do the products case for it. It turned into being one of the largest products cases our firm did in the history. Here's another one. This was a lady that was hurt at work. And you look at this and you go, look at that picture. That's not very much damage. How significant can that be? Well, we rolled up our sleeves. She had a bunch of significant traumatic brain injury symptoms that actually ended up being valued. It settled before trial, but it settled for 1.625. And you go, how is that possible? Well, that's the secrets I want to share here today. The first is a handout that I gave prior to this talk. This is what is known as the spotting the big case checklist. And really what we ended up doing is I got tired of my office being in a situation where I would hear the office that, you know, we spend all this time, resources, going to conventions, talking to people. We do all this work to try and get the phone ring. And then the person answering the phone would say those words that I basically banned them in our firm from being said. And what the words were is, we don't do that kind of law. Because there's always a way to try and add or help value without getting them to hang up. We do the personal injury component, the third-party cases, and I kept hearing my people say, hey, that's just work comp. You're going to need to call this work comp firm, or this is what we need to do. And I got tired of then looking through it and being like, well, did you check for product liability? Did you check for failure to maintain? What about, did they take something off the power press, or did they conceal something? Or was there third-party negligence, which is by far and away the most common one? And when we started asking those questions, I kind of internally started keeping track. This happened about 5-7 years ago. I think the firm, in cases that we got that we would have normally referred on or not taken, the amount of money that our firm and help that we've been able to give to clients is incredibly significant. I would say, I won't give numbers, but let's just say it's way, way more than you would expect, just because, yeah. You don't realize how much your intake people are there to answer the phone and try and solve the problem, rather than be looking for ways to add value or spot the case. So as part of the handout, this was given to everybody. I'm happy to talk through some of the specifics of it, but in showing you a couple of these slides, I'm going to show you where we actually ran into the exact same problem. And because we had this checklist, our firm was able to say, yeah, we're going to be able to do this. The next part about intake is listening is by far and away the most valuable thing you do in intake. I also told a lot of my front office that a lot of times they're not answering and on the phone 24/7. We have multiple people answering the phone. And if you have any hint that there's some significant issue going on, you're to stay on the phone with them long enough until they explain the entire issue. The reason for that is the client's story and what they're gonna tell you isn't the actual story of the case. They will call up, and this is a great example, is you got to be looking for ways to make it a case, looking for how what their story is doesn't line up to legally what it is. They're not the lawyers, we are. So the question I always make my office ask is, who's the employer? Because we had a case that this is a wine tank that failed. This was a work comp case. The wine tank, basically we had an employee standing in front of us. This door failed and it threw him 10 feet back into a concrete wall. He got a head injury, multiple orthopedic injuries. I'm moving along a little quick because of time, but basically what ended up happening is the phone call came into our office. I need a work comp lawyer. I was hurt at work. And instead of just saying, okay, here's the work comp lawyer, we asked, who's the employer, who's on your paycheck. And it turns out when we got a copy of the paycheck, who he said his employer was and who actually was on the job, and the maintainer of the tank, going back to that big checklist. You go back here, it talks about on the second page who the multi-employer, who he thought was the person was not the person. And so all of a sudden, instead of Camus Vineyards being the one that we're going to do, it's the other party that we can really step in and say, hey, as much as they're the employer, this part's going to be work comp. The third party case was a really significant third party case we were able to go make work. So the last bit of wisdom I want to share before I start thinking about passing it over is one of the most valuable things that I've discovered recently that everyone who's doing work comp needs to think about is when you're doing third party cases or you're coming at it from a work comp angle, you'll always be saying, oh, here's who we send our PI cases to here, or we're going to do them ourselves, or here's how we're going to do it. The type of firm you're referring the personal injury case to matters. And what you want to be asking is, are they a more volume oriented firm, or are they a trial firm? And the difference is this: volume firms tend to have between 70 and sometimes 100 cases per lawyer. They are great at doing quick turnarounds of a single orthopedic issue. If you break your ankle or you have a shoulder issue, they're very good at working that up, getting good value out of the case. But if you send a significant traumatic brain injury case to a firm that isn't going to put the resources in behind it, you're going to get a different type of settlement and different type of referral per the professional rules of conduct than if you were to send it to a trial firm. The reason for that is the secret that I learned as kind of a younger lawyer, and it is this. I asked a senior adjuster who retired from one of the major insurance companies. She was the senior casualty adjuster, meaning she's the person that writes the largest checks to settle cases. And I said, what's the secret? What's the biggest way? What's the thing that lawyers, personal injury lawyers, don't understand? And she said, the number one thing we ask when valuing cases is, what's the name of the firm behind it? Because they will give different value to different firms depending on the type of resources they think that firm's going to put into it, number one, and how often they try cases. It's something that needs to be considered, so that if you have a whole bunch of cases going to one area, you want to make sure that that firm is going to put the resources into it to get that client what they really need. So I know we're pressed on time, so I'm going to kind of go through it. This was one example. This was a product that exploded at work. Guy came in, called up the firm and said, I got hurt at work. I need a work comp lawyer. And we started looking at it and going, this is a products case. This is, as much as you want to do work comp, you need to do a third party case against the manufacturer, even though it was manufactured 20 years ago. So here's some air crash cases. I'm not going to talk about that, skipping through that. The real point of this, and I'm going to wrap up with this story, is it's a it's a fun story that I like to say. It's two fish are swimming together in the ocean, two young fish, and an old fish swims up to him and goes, hey boys, how's the water? And the old fish swims by, and the younger fish looks at the other young fish and goes, what the hell is water? And the point of that story isn't necessarily anything other than the most important thing that I can give to you listening to a talk like this is circling back and looking at a case like this. You look at this photo, hurt at work, and you think, there's no way this is even a case that needs to be referred. Or you get someone that says, hey, I got hurt at work, it was my own fault. You need to have the awareness to say, hey, it may be worth having another firm look at this, because there is significant value in some of these personal injury cases if the injuries add up to it. So in spotting the big case, I'm giving you three things. I'm giving you the checklist that I built because it sits on the desk of everyone in our office that they have to go through before they can hang up when somebody says, hey, I've got a work comp case. We make them go through it. The second is the TBI symptoms. If anyone has any loss of consciousness or confusion around the incident, you need to make sure they do that checklist. There's a lot of TBIs that are missed. There's 1.6 million TBIs a year. They're rapidly underdiagnosed at the ER. And the last 2 trials I've done about TBIs, the ER missed them. And that's okay. You can still have a good, significant result. And the last one is ADLs and IADLs. You guys all talk about that a lot, but that's something that if anyone's having difficulties with their activities of daily living or independent activities of daily living, you need to start thinking about, is there a way to make a third-party case on this? And anytime you aren't sure, we just would say, hey, reach out, ask somebody. All the third-party lawyers and personal injury lawyers love looking at cases, and they'd be happy to do it for you. So I'm going to hand it off to there. I was trying to keep my time down, but yeah, John, thanks for inviting me, and I really appreciate it.
Well, thank you. I appreciate it. So, and thanks for what you shared. I was kind of interested to find out at this TBI conference that a lot of the folks that have brain injuries, they're asked if anything's changed for them, and they kind of deny that they've had anything bad happen to them, which I thought was kind of...
One of the, being brief, one of the big issues that people run into is no one wants to admit they're hurt. Everyone wants to assume they're fine. One of the largest brain injury cases our firm worked on, the guy walked into our office after being told, hey, these are the guys that handle those brain injury cases. He walked in our office and said, hey, I have a property damage claim. Can you help with my car? I need the $3,000 for my car. And we started talking to him, and his car had rolled 4 times down the freeway. And that's what he comes in at. And it's the reason that you can't spend enough time listening to the client. As much as it's painful, and there's people that are like, I don't want to talk to the client anymore. This isn't something we're going to do. Let's pass it off. As soon as they say, hey, this isn't something we do, we're not adding value to the client's lives.
And can I just say, I was going to say also, sometimes the clients don't really know that they even have a brain injury, or they don't know, they might be repeating themselves multiple times, and it's something that we can catch, but to them, it's not apparent. They don't really know that they're doing what they're doing.
And adding to that, Erica, one of the things, if you suspect your client, one of the signs and symptoms is the client's more difficult than other clients. Sometimes they're just difficult people, but if there's enough trauma to the head or the chest, there's significant trauma to the chest, it can also cause a TBI. You should consider talking to one of the relatives, family members, and say, hey, have they changed since the incident?
Yep. Cool. All right. So I'm going to go ahead and move on. I got a couple of questions for Erica. So I know we talked before this, and you said that you treat every case unique and different. How do you set up the case to meet the needs of each type of injured worker?
So pretty much what we do in our firm, I really am hands-on in the intake process and the screening of all of that. So typically, you have to take each case individually, because no injured worker or applicant is the same. We say that, you have to take them as you find them, so to speak, and that's true. And you have to set up and strategize what's best for them. For example, like a single mother who's been working at her employer for many years, and she has a straightforward carpal tunnel case that she wants to return back to work. That's not typically the type of case that you might pull on psych and, have all these other compensable consequences and filing, additional cases like, 132A or retaliation against the employer if, to create bad blood or anything like that, if that's her end goal is to get the surgery, go back to work and provide for her family, right? Versus somebody who, is older and may possibly need a Medicare set aside, may need Social Security disability. We're looking at retirement aspects, things of that nature. You wouldn't set it up in the same regard as the prior example.
Yep, gotcha. And so you set up everyone different right from the start?
Yes, I mean, we have the intake process is I feel is the most important process of the pretty much setting up your entire case, because the information that you're going to collect in an intake is also, how you're going to develop the record and how you're going to pursue discovery. And ultimately, if you do a very thorough intake, there won't be surprises or as many surprises as you're going through the case. You know, we advise our clients that as you know, the advocates, you know, we will prepare your case as if we are going to trial. If we are able to achieve a settlement prior to that, that's great, you know, a buyout, lump sum, whatnot. But if not, we have a duty to litigate and to do discovery and develop the record and flesh out all the issues that there may be on your case. So a lot of the questions in the initial intake that I ask are, so there's no surprises, are typically, you know, in the beginning, I'll go into kind of like their personal information, right? And I'll ask them, you know, where do they live? Who do they live with? Do they have friends and family and neighbors nearby? Do they have children? And it's not to be nosy or to go into anything, but I also am looking at the bigger picture, right? So if the applicant or the injured worker is going to have surgery and maybe they live alone, well, then they're going to need home health care. They might need cleaning services. They might need other benefits that potentially the insurance carrier might get away with if we're not looking at all these aspects, and the injured worker wouldn't know that they have those options even available to them, right? Which would mainly be like setting it up with their doctors, getting the RFAs, getting the requests for additional care because of their limited resources at home. Other times too, I will ask about the, you know, if they're married or if they're, you know, in a relationship and, you know, or if they're sexually active, and it's not, again, not to pry, and it may be very personal. Sometimes, you know, typically kind of the men, they don't really want to disclose that, but it goes towards the fact that if you have an injury, especially like a physical injury or even, you know, mental psych, you know, there's also the compensable consequence of sexual dysfunction, right? So, and the medications that they're ingesting. So that's really important because, you know, what we were saying before, like your activities of daily living, if those are very limited and they're limiting your capacity to do what you typically normally would be able to do, then essentially, you know, you should be, or you could be adding and amending those onto your claim to see if liability will be accepted by the defendants for those, if that makes sense.
It does. And so what do you talk to them about with their with regards to their communication with the doctors?
So with the doctors, you know, we basically tell them that, and I kind of use this quote, like in our industry, quiet mouths don't get fed. So if you really need to speak up about your symptoms, and it's not that you're being pushy, it's not that you're being naggy or anything like that. I feel like sometimes injured workers feel, you know, that they are portrayed in a different view, you know, like they're the helpless victim and they're just complaining and no one wants to hear about what they're saying. But if you don't tell your doctors, if you just go in there and say, I'm in pain, I'm in pain, I'm in pain, you know, kind of give it to them bluntly, like nobody cares because everybody's in pain. That's why you're there. You really need to explain your limitations and your symptoms. Doctor, it hurts when I go to get my seatbelt and put it, you know, across. I can't turn as well, or, you know, I'm lifting certain groceries, or I need help. I can't really do the dishes as much. And I apologize, I shouldn't say can't. It's more difficult for me to do. You know, and I basically just advise them of like explaining to the doctors of what is more difficult, what's more challenging, how it's increasing in pain, their sleep. I tell them, you know, and a lot of them kind of chuckle at this. It's like, you know, think of that song, head, shoulders, knees, and toes. We start with your head and we think about like, okay, you have a back injury, right? But I want you to think about all your symptoms, right? Starting with your head. So your head would be like sleep, psych, are you feeling depressed? Are you not sleeping right? Do you have headaches? Because, you know, the pain can radiate up and the pain can radiate down. And so it gives them kind of a bigger, broader view of sometimes symptoms, because ultimately they'll come in saying, oh yeah, I hurt my back at work, but they don't realize that they have drop foot, or the pain's radiating down their leg, or their sleep is agitated, or they're taking so many medications that they're getting constipated, or the opposite, from having internal complaints. So sometimes you have to dig a little bit deeper, because I think, like as we were saying before, the surface, it's very easy to see kind of on the surface of maybe what's going on, but you really have to dig deep to see if there's additional value. I also kind of feel that way when I talk to them and I ask them, one of my main questions I like to ask them is, in the beginning, are you planning on returning to work? Usually sometimes people with like the longer history or the longer careers, they'll say, oh yeah, yes. So then I kind of know, okay, we're looking at a stipulation, we're, trying to expedite treatment, we're trying to do, if they kind of hesitate, or they say like, I don't know, that kind of can lead into a question of a 132A, because they're not always going to come out and be direct with me when I say, how has your employer treated you through this process? Sometimes they don't really want to talk negative about their employer. They don't know what's being said or what they can disclose. So they'll say, oh, it's fine, it's fine. But if they don't want to, or kind of plan on returning to work, there's a reason being why. Maybe they feel that they can't do the job. Maybe their employer is retaliating against them and giving them a hard time for filing a case, which then leads through the 132A questions. So I kind of that's a good lead in for me to kind of feel them out. And I tell them, it can always change throughout the case. You think that, or plan on going back to work, but, sometimes plans change. So, at this point in time, where do you see yourself? It's kind of the same thing as well as, on our intakes, it says, third party, are there third party, or is there like a serious and willful? They don't know what that means, so you have to kind of, in layman's terms, ask them, so have, you're saying that the door was, loose on the hinges that was swinging. Did you report that to anyone? And, or maybe not officially, but did you mention it to somebody, or did you, talk about it, or, and you don't have to tell me now. And I always tell them, there's a statute of limitations, and, but think about it, go back through pictures. Maybe you in your phone, you took a snapshot, and maybe you just, giving them trigger words to kind of re-jog their memory, right? Because to be honest, if you were to ask me on the spot, what I had for breakfast or lunch 2 weeks ago on Tuesday, I would not be able to tell you, right? So.
Yep. Oh, for sure. So it sounds like you take a lot of time on these. How much time do you take on your average intake?
I do. We usually, so we'll do like a initial preliminary screening just to get the information. And then I really will spend anywhere from minimum more than like an hour onwards, because I really like to get into the, details of not only their injuries and past injuries, but pretty much it's like their entire case or their entire life, right? In this period of time, because I don't like to have surprises at a deposition where they're going to be asking all the same questions, and it would not be fair, and it would not look good if you're not knowing that they had the, prior injuries, or they had, high school injuries, or just anything of the sort, or that they have like 4 babies mamas, and like they're not like paying child support, but yet they're just everything all over the place. You really need to know exactly who your client is, and what you're dealing with, as well as their kind of how they see themselves, because when they're explaining to you about their injuries, and some people can come off very timid, and oh, I'm so sorry, I'm here, and you really need to like make them feel comfortable, right? Versus the person that comes off saying, hey, you work for me and you need to listen to me. You also have to know how to deal with that personality as well. So
I know Goodchild and Duffy is a very busy firm, and you have lots of clients. What would you say to an attorney that says, you know what, I just don't have time for that amount in intake? What would you say to them?
You know, if they don't have the time in the initial intake, what I would, you know, mainly say is, okay, well, you can go ahead and you can set up meetings, you know, or periodic meetings to follow up with the client. I mean, get the pertinent information. And, you know, you can continue on. I mean, our intake process doesn't just stop really at the intake process. When we send out the documents, they have to provide us with paycheck stubs and all kinds of, you know, employer, notifications. And sometimes I'll be like, oh, you have a panel QME list right here. And they're like, what's that? You know, they don't really know. So it doesn't really just stop, but I do have a very good foundation of where to start.
Good deal. Well, thank you. I think this helps everybody quite a bit. I'm going to go ahead and move on to Eric. And so Eric, you deal mostly and almost exclusively now with SIBTF, correct?
That's right, John.
Yeah. And so one of the things we talked about is there's 5 elements that you need to have to establish eligibility. Do you want to talk a little bit about that?
Sure, John. And thank you for the opportunity to talk about SIF. I want to start, if I can, with a word of encouragement to the applicants' attorneys out there in the audience. If you're doing SIF work, good on you for doing that, and keep at it and learn how to do it as well as you can. You're providing an important service to your clients. If you don't do SIF work, I want to encourage you to do so. I know it's hard, and a busy applicant's practice can be all-consuming. I know how it is. I've been there. But I want to encourage you to take up SIF practice, learn about it, and jump in with both feet and give these cases a try. The reason for that, really, there are 2 really important reasons for that. These clients are deserving. They come to you with pre-existing disability, some of them serious. And despite that, they've been in the labor market working. And they had the misfortune of sustaining an injury on the job to compound the pre-existing disabilities that they already had. So these people are heroes in my book. I mean, they've got pre-existing disabilities, but they're out there working and earning a living. So they're deserving. That's an important reason for doing these cases. Secondly, an SIF case, by its very nature, is a life pension case. And oftentimes we're talking about a permanent total disability as the combined disability. These cases are significant. They can be life-changing. I've had clients buy their first houses as a result of an SIF claim. I've had clients save their family home that they've lived in for years and are about to lose it. They get an SIF award and they're able to keep their homes. So these cases can be life-changing. You've got deserving clients and life-changing benefits that you can help provide for them. So it's important reasons to do these cases. So the 5 elements, John, you asked about those, and they're important in spotting an SIF case. And I think it's helpful to start with a little bit of a history lesson. So in the handout, I gave you just a couple of aspects of the history of SIF that I believe are important for learning the skill of spotting the issue. And the first historical fact that I'll point out is that the fund came into California in 1945. That's when the legislature passed a bill. This was the second attempt to start a subsequent injuries fund. The first attempt in the 1920s was struck down on constitutional grounds. This bill that was passed in 1945 survived a constitutional challenge. And so we've had the fund in California since 1945. Now, what was happening in history in 1945? World War II was ending. And so we had all of these veterans, thousands of them coming home from the war, men and women. with disabilities, some of them very serious. And so the legislature wanted to encourage employers to hire people with pre-existing disabilities. And the encouragement comes in the form of the employer is shielded from liability for paying for the pre-existing disabilities. And it provides assistance to those with disabilities by giving them additional compensation in the form of the subsequent injuries fund benefits. So the purpose is to encourage and assist. Keeping that history in mind, the 5 elements, John, you asked about those. I provided 3 major ones here in the handout. And the first one is a pre-existing disability. There's a little bit of shorthand here. The cases talk about the standard that you have to meet in establishing a pre-existing disability. The standard is actual labor disability. That's the language that the courts use. So we kind of did shorthand here and said pre-existing labor disability. Think of those veterans coming home from World War II. They had, some of them, significant pre-existing disabilities. So when you're sitting down with a client for the first time, Erica was talking about doing the intake on an applicant's case and going extensively into the client's medical history. That's especially important from the perspective of the SIF. You want to have a very broad discussion with your clients about their medical history to try to uncover any source of pre-existing disability. And again, the standard is actual labor disability. And for those in the audience who think that SIF is just too hard, you don't understand it, and I just don't want to do it, it's the same disability analysis that you do in your applicants' cases. This practice is not impossible. It's doable. You can learn how to do it. It's the same analysis that you do in your claim for regular benefits. Second element is you must show that there's a compensable subsequent injury that rates 5% and affects an opposite corresponding member, or that rates 35% itself. And those measurements are done, the 5% or the 35%, after application of the DFEC and before apportionment. So you get the benefit of the DFEC modifier. On more recent injuries, that's a 1.4. So you do the math, and for 35%, you need a 25% WPI. You apply the 1.4, you get the 35. The 5% opposite corresponding, sometimes there's a misunderstanding that the opposite corresponding member has to rate 5%, and that's not correct. The injury has to rate 5% and affect an opposite corresponding member. So it's the injury that has to meet the 5%, not the opposite corresponding member. And finally, the third major element is the combined disability has to be in the life pension range, has to be 70% or more. And the combined disability in SIF parlance means the pre-existing disability combined with the industrial disability. So those are the 3 main elements. The other 2 are relatively minor. We don't see a lot of litigation with respect to those. You have to show, the 4th element, if you will, is you have to show a compensable injury that causes additional disability, a compensable subsequent injury that causes additional disability. So you have to meet all the requirements of injury AOE, COE, and that injury has to cause additional disability, additional meaning over and above the pre-existing disability. So what that means is, if you get a take nothing, you go to trial and unfortunately you lose on AOE, COE, and the judge's finding is an order that your client takes nothing, you've failed this requirement of eligibility for SIF. You don't have a compensable subsequent injury. Also, if you stipulate or there's a finding that there's 0 permanent disability on the subsequent injury, you fail this requirement as well. You've not shown additional disability over and above the pre-existing. The 5th element is that the combined disability must be greater than that caused by the subsequent injury by itself. So in my head, the way I abbreviate that is combined greater symbol industrial injury. So the combined has to be greater than the industrial injury. Where that becomes an issue is where OD Legal, that's the office that defends the subsequent injuries fund, comes in and says to you, well, John, your client's subsequent injury rates 100% by itself. And so the combined disability, even if it's 100, can't be greater than the disability on the subsequent injury. It's 100. Those two requirements that I didn't list here, we don't see those often in litigation. These are the three that get the most play. And by far, the one where we have the biggest fights is the first one, establishing pre-existing disability. And so when you're doing your intake, I encourage lawyers that I work with in teaching them how to do SIF practice. You want to be thinking about SIF from the very first meeting with a client. And so when you're doing your discussion with that new client on apportionment issues, let's say it's a spine case that the person's there to see you about, you're going to be very interested in any prior spine injuries or anything affecting the spine, any medical condition that affects the spine.
Now, do you go ahead and find out when they were treated right then, or where they were treated at that point, right at intake?
I do, yeah. I ask questions about, medical providers, doctors' names, hospitals, clinics, etc. For an SIF case, you're also going to want a broader discussion about the client's medical history. You want to explore whether they have any prior medical condition or prior injury, and it can be literally anything. It does not have to be an industrial event, a prior work injury. It can be non-industrial, it can be congenital, it can be something that arose, some pathology that arose later on in life. It can be from any cause. The main element that you have to meet, the main standard that you have to meet in proving pre-existing disability is there must be, again, actual labor disability. And so I gave you some of the elements that I look for, some of the factors that I look for in assessing whether a client has pre-existing disability in the handout. If the client is a repeat customer, if you've represented them before and you got them an award of benefits and they're in your office for another injury, you might think about whether they have a subsequent injuries fund claim. So they have a prior award already or prior injury that caused some disability already. And then just exploring their medical history more generally, anything they were born with, congenital problem, anything that required them to go to a doctor on a regular basis. It's important for you to evaluate that. If they changed occupations, sometimes people will change occupations because they're no longer able to do the work in the job where they were. And so they had to move to something else. It could be an indication of disability. If the applicant observed limitations before their work injury from any cause whatsoever, so if there's anything limiting their activities of daily living, you want to explore that and find out what's going on and whether there are factors of disability that you could argue as pre-existing.
Gotcha. So I got a couple of questions that popped on here, and one is from Jenny, and it's quite a long question. So Jenny says she recently lost a trial in SIBTF case due to not joining the SIBTF until 2 years after the case settles, and it was 9 years since the DOI. The WCJ ruled that it was time barred. I argued that there was no statute of limitation in these types of cases and that it was filed in within a reasonable time as applicant had attempted to return to the labor market and actually found a job she was able to do for about 17 months, but then had to stop working because she was in too much pain. They're currently waiting for the recon unit's decision on the petition for recon. They argued in their petition that the WCAB should reconsider the merits of the case, which the WCJ did not. and that our client could not have been aware that she was 100% until we obtained the internal evaluation, which was the report that put the case over 100%. We also argued that we needed the VR specialist report before we knew she was 100%, and we joined the SIBTF shortly after we received that report. We also argued that the SIBTF was not harmed by the delay in joining them. So our question is, what are your thoughts on whether this WCJ was simply wrong about her interpretation of the law? She cited the Moore case, or was the WCJ's determination consistent with the other WCJ's decision on the statute of limitation issue? Long question.
That's quite a long question. So first of all, there is a statute of limitations with respect to SIF. It's weird, I'll grant you that. If you look through the labor code, there is no provision in the labor code defining a statute of limitations. So there's no quote unquote statute. And I've heard some judges, when OD Legal raises a statute, they'll say, well, what statute? There's no statute. And that's correct, there isn't. However, there is a statute of limitations developed through case law, and it's one of the oddities of this particular practice. You have two California Supreme Court cases that are very important on statute of limitations in SIF. That's the Talcott, T-A-L-C-O-T-T, Talcott case, and the Baca case, B-A-C-A. And if my memory serves, those are both at 35 CCC. So if you look in the 35th volume of the California compensation cases, I believe both of those cases are there in close proximity to each other. The Supreme Court was very busy on the statute of limitations issue that particular term and issued those two decisions. And the statute is weird. It will sound familiar in some respects. The statute can be summarized like this. The court in Talcott held that the injured worker, if the injured worker has notice of eligibility for SIF, then the injured worker must file within 5 years of the date of injury. If the injured worker did not have notice of SIF eligibility, then it's a statute of reasonableness, must file within a reasonable time, and that depends on the facts of each case. Then some subsequent case law holding that where the injured worker doesn't really know what the degree of disability is, it's reasonable to file within a year of determination of disability by the WCAB. And a determination of disability by the WCAB has been interpreted to include stipulations with request for award. That's pretty obvious. Findings and award, that's pretty obvious as well. But also compromise release is considered a determination of disability. So there's the statute. It's not easy to summarize it. It's kind of a cumbersome statute developed by case law, but it's there, and you need to be aware of it. So the facts of this case, if I remember all of them, it's 9 years post-injury that they filed the application against SIF, and 2 years from the time that the claim for regular benefits settled. You know, I'm not gonna, I couldn't give an opinion about whether that's a valid statute of limitations defense just based on those bare facts. But you're nine years downstream from the date of injury. If there's an argument that you knew within 5 years of the date of injury of potential eligibility, could be a problem. 2 years post resolution, you know, it's a defense that OD Legal is arguing more frequently now than they ever have before. You never heard about statute of limitations ever before. And I think for a long time, practitioners, even who did SIF fairly regularly, assumed that there really wasn't a statute of limitations. Those Supreme Court cases were not all that well known until more recently. It's become a defense that we see more often now.
Gotcha. Okay. I got a question where the answer is, it depends, which is always my favorite attorney answer, right? So when working on SIBTF cases, do you have a designated department, or do you just assign a couple people in your office 1 day per week to work on the SIBTF cases?
I'm the department. And my paralegal, who is very good at administering these cases. I think it's important that I know there are law firms that have paralegals or legal assistants do the intake process, and I suppose that's fine. That was never our choice when I worked with the law firm that I was with in Sacramento. It's not my choice now when I'm on my own. I do the intakes. I sit down with the client from the very first time. I think that's important. I believe that's important for the lawyer to do, or somebody who's very knowledgeable in this area of practice, because it's essentially a law school exam when you sit down with the client for the first time. The client is giving you their version of the facts. And as Taylor pointed out and Erica pointed out, sometimes the client's version of the facts is not the whole story. You need to dig deeper and find out the relevant, important facts. And it's a law school exam. I mean, it really is. You're issue spotting and trying to figure out what kind of claims this client can bring.
Gotcha. So Erica, how does your firm deal with it?
So we don't have a department. We just, handle the cases simultaneously with the work comp cases, and, we do both.
Yeah, I've seen it a bunch of different ways. I've seen some of the larger firms that do have an SIBTF department. I've seen some firms where they're small enough that everybody handles everything, right? And then I've also seen some firms that said, you know what? I don't know enough about SIBTF and don't have the time to do this correctly. Let me give it off to somebody like Eric, right? So I've seen kind of, I would say it's very much it depends, right? I do have another question from Jenny on SIBTF. So my second question is regarding SIBTF's position that they will rely on the QME or AME in the underlying SIF case. And if that report does not meet the 35% threshold, then they don't care if the physician's report she obtained in the SIBTF case meets the 35% threshold. SIBTF is also taking the position that they will not consider body parts not included in the underlying subsequent injury case, which allows them to argue the threshold was not met. What are your thoughts about these arguments?
Okay, so there's really two questions in one, John. So the first question, as I understand it, is OD Legal will argue that the PQME or AME reporting in the underlying claim for regular benefits does not meet the threshold. They're going to rely on that reporting. And then the second part of that argument that I understood from the question is that OD Legal will not look at any QME reporting that the applicant obtains in the SIF case.
Right.
Okay. A couple of points on that. First, the applicant has the right to obtain a QME report from a physician of the applicant's choosing. It's old-fashioned QME rules. Old-fashioned meaning before the panel QME system, where the parties got to choose their own QMEs. As the applicant, when I'm representing the applicant, I can choose the QME who is going to evaluate my client's SIF claim. And obviously, you want to choose physicians who have a lot of experience with SIF reports and they know what they're doing. That's admissible in the evidence. So that part of the argument in the question where OD Legal won't consider the QME opinion that you've obtained in your client's SIF case, it's just not a very effective argument. We have a right to that QME report, and it goes into evidence. And it's part of the evidence that the trial judge will be looking at. So if OD Legal doesn't want to consider it, the trial judge will.
Okay.
Or should. Okay.
Yep.
The second part of that question, I'm forgetting now. The second part of the question, I think, was dealing with.
The SIBTF is also taking the position that they will not consider body parts not included in the underlying subsequent injury case.
Thank you, John. Okay, thanks for reminding me. And that is a legitimate problem and a legitimate argument that OD Legal is making more these days. It puts a premium on, just for context, what OD Legal will argue is, look, you stipulated to spine, headaches, and dental in the claim for regular benefits. You cannot now allege psyche and hypertension and et cetera, beyond what you stipulated to in the industrial injury, okay? So this is an argument they've been making, and they've been getting some traction with it. The reason for that is there is some case law dealing with the effect of stipulations. The Weatherall case is Weatherall versus, I think, City or County of Sacramento, if I remember correctly. And it essentially stands for the proposition that a stip is a stip is a stip. If you've stipped to something, you are bound by it. And so any stipulation that you make, any provision that you agree to in settlement documents, in particular, in your claim for underlying claim for regular benefits, you will be held to that in the SIF case. So what that does is it puts a premium on alleging every possible body part that the industrial injury affects. If you do that, even if they're denied, and the defendant can put a provision in the settlement document that says these are disputed body parts, and a disputed body part is fine. You can still allege it. It's still part of your claim. You can then use it in the SIF case. You just have to be very careful about identifying and listing the body parts in your settlement documents in particular, or if you are going to trial on the case for regular benefits, you want to allege everything that's possible related to the industrial injury that you intend to make use of in the SIF case. If you intend to use it in the SIF case, you better put it in the claim for regular benefits.
That makes sense.
Yeah.
Well, I think that's all the questions that we have. In the interest of time, I think I'm going to go ahead and try to wrap this up. I do want to thank all of the panelists for joining us today. The interest of these is to try to give everybody something that you can walk away and use in your practice right away. And hopefully we did that for you. This is going to be recorded. I will get the recording out to all the participants. And again, thank you for joining.
Thanks again, John. We appreciate it.
Yeah.
All right.
And thanks,
Thank you.
Gemini Legal.
Have a great day.